My name is Bethany Servin, and I work in marketing here at UsableNet. Today's webinar is Navigating Web Accessibility Law in 2024. This webinar is produced by UsableNet, a recognized leader in accessibility and digital inclusion. And our first speaker is Jason Taylor, our Chief Innovation Officer. I'm now going to hand you off to Jason, who will get us started.
Thanks, Bethany. And thank everybody for taking some time out of their busy days. First, I'd like to introduce my sort of co-presenter. I'm really happy to have Chuck here because essentially his experience is going to give us probably most of the detail over the next hour. Chuck, maybe you could just introduce yourself and your partner and your firm, give the audience just an idea of the types of work that you do for which types of companies in which space.
Yeah, thanks, Jason. Hi, I'm Chuck Marion. I'm a partner with Blank Rome. We are a full-service law firm headquartered in Philadelphia and founded in Philadelphia, where I'm based. But we have 15 offices throughout the United States. We're really a national firm. And I'm a general business litigation attorney, but I do a lot of litigation and counseling in the area of the Americans with Disabilities Act and similar state and local laws, primarily representing, I'd say mid-level to large businesses. So usually I'm on the defense side or the giving advice to businesses with respect to ADA issues and compliance.
Great. And let's just quickly look at the agenda today. Chuck and I wanted to achieve sort of three very sort of distinct things for the audience. One, we just want to bring you quick background how we got where we are in the case of lawsuits which are essentially made against websites or mobile apps or digital properties where ADA is the referencing claim. And then I'm essentially going to lean a lot on Chuck on sort of just giving us an idea of what's been happening in 2023, but really what's going to happen in 2024. What do we see are the highlights? It looks like 2024 is going to be quite a busy year in this particular space with regard to the legal stuff. But I feel that some of that groundwork's already been done in 2023. So Chuck can probably have a good idea of what that's going to look like in 2024. And then we hope to give you some takeaways in terms of how to best prepare yourself to make sure that you're increasing the accessibility of your digital properties at the same time reducing your risk against some of these legal aspects. Overall, what Chuck and I would like to do is, leave you more informed and knowledgeable, so you're able to act upon that. But also, obviously, if you're in an organization and you're called upon to sort of explain what's going on in the legal space or what could happen in 2024, you sound well informed and knowledgeable in that space. That's our sort of goal of mine and Chuck. So let's start with sort of where we are today or how we got here. Essentially, a lot of people were probably aware that there's lawsuits that are brought against companies that have websites and apps, and that's been going on for a long time. In fact, lawsuits have been going on since 2000, so over 20 years, essentially, where a lawsuit's been brought against a company's website because that user has felt that they can't use that website in the same way as other people. They use assistive technology and they feel discriminated against, and they've used the ADA as that sort of background for claiming discrimination. I think the important thing here is to understand is that these lawsuits have been going on for a long time, but in the early days, they were very much a small collection of what I class as advocacy groups like the National Federation for the Blind that recognized that websites and apps were going to be the future. It was going to be the future of how people got educated, how people managed their finances, how people worked, and how people shopped. And essentially, those original lawsuits were brought by advocacy groups saying, this is really important. We need to be part of this digital world. And the Department of Justice agreed with that. And the Department of Justice joined those types of plaintiffs to push large organizations at that time, which are things like Bank of America, H&R Block, universities, to recognize that they should be making sure that their websites and apps are accessible, and essentially making those companies end up agreeing to settle and agreeing to make their websites and apps accessible. That was an ongoing process for about 15 years. Department of Justice always sort of had a position where websites were covered under the ADA. Websites are a place where people do stuff, is where commerce is done, is where people bank, and that should be made accessible just like any other physical space. So essentially that's how the ADA got attached to digital spaces. And I'll let Chuck sort of give his little view as well. But what you should understand is that the Department of Justice had a view that they were going to make it very clear what companies had to do, by when, how often. But they basically gave that up in 2017. And in front of me right now is a slide. I'm going to explain it a little bit, but essentially it shows that from 2000 to 2017, there was a smaller number of cases, and most of them involved the DOJ. But after 2017, essentially a void was left. The DOJ had established that websites were subject to the ADA, but not made it clear what that meant from a technical perspective and a business perspective. And it allowed plaintiffs who wanted to target a volume of companies, that sort of gray area that they could use, that sort of templates that the DOJ has used. And essentially those lawsuits exploded in 2018 from, around in the world of hundreds before to the world of thousands. So today we expect somewhere around 4,000, 4,500 companies to be sued this year.
Yeah.
Is there anything you'd add to that?
Yeah, well, under the Americans with Disabilities Act, it is the DOJ that's tasked with implementing rules to enforce it, and guidelines and guidance. And as you pointed out, the DOJ was pretty active early on when the internet was growing and websites were becoming important, and involving itself in cases and helping get settlements where companies agreed to make their websites more accessible. As you can imagine, with government, with a change in administration, the policies and priorities change. And I guess when Trump came in, he kind of put aside the whole process of making rules in this area. So look, a business wants people to have access, of course, to its goods and services and its websites. But the way that this has played out, with a lot of lawsuits being brought by, I'll say enterprising plaintiffs' lawyers and their clients, while everybody wants disabled and really all individuals to have access to their websites, a lot of businesses just feel like there's no clear guidance and rules and standards for what they have to do to make their websites accessible. And they find themselves possibly having to pay to settle a lawsuit, and then maybe pay to update their websites as well. So with all the things that have gone on in the world in recent years, with inflation, supply chain problems, as you can imagine, businesses have a lot to deal with, and this is sometimes not in their budget or not at the top of their list of priorities. But because of all the lawsuits, the courts have had to deal with this, and businesses have, I think, woken up to this issue, and they're certainly aware. And we're going to talk about some things they can or should be doing to help minimize the risk of these lawsuits and claims. Yeah.
And I mean, for information, if we go to the next slide, I think this is, if you've never seen this slide before or never heard us talk about a typical week. So these lawsuits get filed every week. They're a general flow of lawsuits every week, probably 80 to 100 lawsuits a week across the United States. But as Chuck sort of alluded to, this is a very aggressive small group of plaintiff firms, typically between 10 to 15 plaintiff firms across, that focus about 80% of these lawsuits across the year, that represent maybe only about 20 plaintiffs. So this is not 4,000 individuals that have struggled with a website and got 4,000 lawyers to go represent them. This is more of a systematic approach to trying to enforce what they believe is their right to essentially sue companies that they don't believe are supporting them in the digital space, and they're using the ADA to force that from a legal perspective. There's you could talk a lot about whether the ADA really applies or doesn't apply, but from a practical point of view, essentially there's enough support at sort of the judge level and case level to mean that you have to respond to these lawsuits. So, I mean, actually, this is the third point on here is that 70% of the filings are actually in New York, and the rest of them are mostly in California and Florida. And that leads to sort of ask Chuck, why is that? Why is New York so popular for these types of lawsuits to be filed?
Well, I guess to back up historically, the ADA was passed in 1990. I think it went into effect in 91. And of course, many people weren't even using the internet. Most people weren't using the internet back then. The law itself, the particular section or title of the law we're dealing with is Title III, which deals with places of public accommodation. In the statute, it lists different types of what those are, like hotels, banks. They're all physical locations. The law actually says nothing about websites or the internet. But as you pointed out, Jason, over the years, and in part driven by some advocacy groups and the plaintiffs' bar, the Department of Justice has taken the position that the ADA does apply to websites. It just hasn't really clarified exactly what rules do apply and what a business has to do to make its website accessible. But there's also a split around the country about whether if a person has a problem accessing content on a website, if that alone can be a claim under the ADA, or they have to tie it in with some inability to then take advantage or enjoy the goods and services at a physical location of that same business. Well, New York is in a district, the district courts in New York and in that circuit where it is, they've generally taken the position that it's okay just to have an issue on a website alone. You don't have to allege anything about trying to also go to a physical store or bank or hotel or anything like that. So New York has been pretty lenient in allowing these claims to proceed just with e-commerce websites. And I think that's the biggest reason we're seeing so many claims filed in New York. California, in contrast, it used to be on the federal court level, but now the state courts are following this as well, do require that nexus, they call it, or connection between the website and an actual physical location like a store or a restaurant. But we're still seeing a lot of claims there. There have been some active plaintiffs and plaintiffs' lawyers in California. And Florida is a little bit of a mess. There was the only case I know of actually of this type that's gone all the way through a trial. It was a bench trial, meaning a judge, not a jury, involved Winn-Dixie supermarkets, and it was in Florida. And Winn-Dixie lost that case. It was a disabled blind plaintiff who said that he couldn't access content on the website in terms of specials at the store or to renew prescriptions of drugs at Winn-Dixie. But anyway, he won that, but then it went up on appeal, and eventually the 11th Circuit Court of Appeals kind of declared it all moot and threw out all the rulings and has left things in a kind of a state of flux in Florida. So Florida, we had seen a decrease in the cases being filed, but they're kind of creeping back up again. So the courts are kind of all over the place, and the law is still very unsettled and uncertain. But in these jurisdictions, the plaintiff's bar has been particularly active, especially in the last year or two in New York.
Right. And it leads me to the sort of last sort of technical point about the lawsuits that we see. They're typically grouped around particular industries. One in particular is e-commerce, so retail and other types of e-commerce like ticket sales or other types of activity, which essentially mean that you're doing commerce online, is a particular focus. There might be legal reasons for it. From a technical reason, I think there's lots of them. So if you're in the business of trying to create lots of lawsuits, they're a good place to start. I think they all work similar, so it's easy to tell somebody, if you imagine that these companies are producing, 5 to 10 lawsuits a week, right? They need a process that sends their sort of plaintiff out to look at certain websites, come up with a general report back about which ones are good and which ones are inaccessible. So, e-commerce is very templated. Typically, they all work very similar, so it's easy to generate sort of a process around testing those sites. I also find that e-commerce sites are complicated. They're changing all the time. So potential to make lots of problems. Again, plaintiffs are looking to identify websites where they believe that they can document problems or different types of issues. So I think there's some technical reasons there. There might be some legal reasons, but the one thing I'd like to just sort of get your view on, Chuck, is when you see numbers, especially numbers that UsableNet post around website lawsuits, we are talking about ADA related lawsuits, whether they're state or federal, and only where the subject matter is a website or an app. So we don't track ADA lawsuits about a physical location, a parking space that's not big enough or a ramp. So the numbers that we report are only ADA digital related, meaning that the subject matter of the claim is a website or an app. But there is another way that you might get a legal claim, and not through an ADA related federal and state, and that's through what they class as demand letters. Maybe, Chuck, you could give a brief understanding of what a demand letter is and how popular it is to be used by law firms.
Yeah, sure, Jason. So some of the plaintiffs in this area, when they do find that there are accessibility issues with a website, they'll have a plaintiff's lawyer, send a letter to that business that owns and operates the website to say, look, your website's not accessible. It's not compatible with the screen reader I use as a blind or visually impaired person to access content. And they basically ask that the business fix the website, but there's usually a monetary component too. While the Americans with Disabilities Act Title III really only provides for injunctive relief, meaning if you go to court, the court would order you to fix the issue. It does provide for the prevailing party, if the plaintiff wins the case, to get his or her attorney's fees reimbursed. So, and then Jason alluded to this earlier, there's also some similar state and local statutes that have also been used by some of these plaintiffs, which do, in addition to the attorney fee provision, if they win, also allow some statutory damages or penalties. So, but yeah, a lot of times the plaintiff will first send a letter to the business and demand that they engage with them and try to fix the problem and resolve the claim, basically. And if not, they say that they'll take it to court. You don't have to do that under the law. You can just go to court. Although there've been some, we'll talk about later, some proposed legislation that would require the first step, like a notice to the business and giving it a chance to cure the issue before a lawsuit can be filed. But none of those laws have been passed, unfortunately, for businesses to this point. So anyway, we've just seen it. I think maybe sometimes it's a matter of style, or the plaintiff's lawyer thinks, well, if we can resolve this without filing a lawsuit, it's quicker. It's, I don't have to pay the court filing fees and prepare and file a complaint. So yeah, we see some of that. I'd say maybe I see that in about a quarter of the situations, a claim letter first, but probably, or maybe 30%, but the rest, you probably just see a lawsuit filed, and that's when the business is first alerted. Yeah.
So that's setting the scene. So the scene is large volume of lawsuits brought by a small collection of plaintiffs and plaintiff firms, right? In the context of there's been a void for many years of real legal updates from the DOJ, and essentially this has been going on and building over the last 5 years. So essentially, this is what has been driving awareness, need, urgency at companies. Essentially, they don't want to get lawsuits. And when they get a lawsuit, they want it to go away, and they want to do the things they need to do to go away. And I say that because what we're now going to talk about is sort of, Chuck's going to take us through. So now the DOJ has actually started to become more active. What's their current position? What are they doing? What laws are they getting behind in 2022 that might come into trade in 24? And how could that change this landscape that we're seeing right now, which is pretty set in stone in terms of the volume and the type and the people involved? So Chuck, maybe you could just give us an idea of where you think the DOJ is right now, and then take us into 2023, 24, what you think might change in the legal landscape.
Yeah, sure, Jason. So, the Trump administration, as I said, kind of put everything on hold in terms of the DOJ trying to make rules in this area. which was a little odd when you think about it. While the Trump administration was anti-regulation, this is an area where if the DOJ gave some more clarity, it would really help businesses figure out what they need to do and how far they need to go with all this. But in any event, when the Biden administration came in, they started looking at this issue again. And the DOJ under the Biden administration has been more active in this area. In 2022, as this slide shows, they did give some so-called guidance in this area, essentially, again, reiterating that businesses do have to make their websites accessible. But it kind of stressed businesses having flexibility in how to do that. And that was good and bad, I guess, in a sense, because on the right side of this slide, what it didn't do is actually come up with clear rules and standards for what, what a business has to do to make its website accessible. It was just kind of a more general, vague, you have to make it accessible and it's up to you how to do it kind of thing. Now, the DOJ has also gotten more involved, as it was when Jason showed that slide earlier, kind of back when Obama was president and back in that time frame, in terms of getting involved in bringing about settlements and making sure businesses are complying and making their websites accessible. When the COVID vaccinations were beginning to be offered, there were some websites offering them that the DOJ stepped in and said these aren't accessible to blind people using screen readers, and they need to be. And they also had some compliance efforts earlier this year with some eye surgery centers in Arizona, with University of California, Berkeley. So the DOJ is definitely becoming more active, but at least in 2022, it didn't give real clear, specific guidance on what a business has to do. So just following up on that, this slide mentions those consent decrees and settlements the DOJ got involved in and brought about earlier this year with the eye surgery centers and one at a university. It's also been investigating the compliance of federal government websites. And in August of this year, it issued a notice of proposed rulemaking that would apply to Title II of the ADA, which deals with state and local government, basically public entities. It basically said that it is looking at regulations and it invited comments. And these regulations have not been issued yet, but apparently the DOJ is working on new rules that would affect and govern state and local government entities, and that could also impact, would impact public entities, including public colleges, universities. And a lot of people think that when the DOJ gets around to issuing these rules, that they will be sort of a precursor or they'll lead to rules for private businesses and their websites that will be similar. They would, under the proposed rule or the notice that was issued by the DOJ, give governments, depending on the size of their population, either 2 or 3 years to make their websites accessible. So, this is government moves slowly and then the compliance process would be a bit slow. But they also, for the first time, the DOJ said that the Web Content Accessibility Guidelines version 2.1 level AA would be basically the standard for website accessibility. And that was interesting. As I think we talked about earlier, there are really no government rules or standards for website accessibility, but an industry group, the World Wide Web Consortium, has developed these web content accessibility guidelines, and they update the versions of them from time to time. In fact, they recently issued a new 2.2, but these have really become the de facto standards when it comes to website accessibility because no one else has really stepped into the void to issue any. So this notice of proposed rulemaking from August of this year, a lot of us lawyers think is fairly important. It obviously shows the DOJ is getting more and more involved again in this area. We don't know if Biden will be reelected or there'll be a change in administration, which could throw off some of this, but at least they're in the process of making rules which could be issued in the new year that would affect state and local government entities and public universities. And as I said, it may lead down the road a little further to rules and regulations governing private businesses and their websites. We can go to the next, So I'll just keep going, Jason, if that's okay. From time to time, I mentioned earlier, the U.S. Congress, various state legislatures have proposed bills to regulate what's going on in this area. I mean, while, again, everybody wants disabled individuals to have access to what's online, there's some that feel like with these so-called serial plaintiffs, these people filing literally hundreds of these lawsuits left and right against all sorts of businesses and entities to bring about settlements. Maybe that's not really the way that, Congress envisioned the ADA working and for the courts to be used. So some of these laws over the last several years that have been proposed would require plaintiffs who have an issue with accessibility of a website to first give notice to the owner and operator of the website, say what the issue is, and give them a certain time period to fix or cure that issue. And only then, if they don't cure it, could a lawsuit be filed. But a lot of advocacy groups like the National Federation of the Blind and a lot of the plaintiffs' lawyers in this area have opposed that type of legislation and feel that those additional hurdles shouldn't be required. On this slide, we show some recent developments in terms of legislation that's been proposed. Kansas passed what's sort of like almost like a punitive statute that would go against some of the plaintiffs and their lawyers who bring these cases. It's called the Kansas Act Against Abusive Website Access Litigation. And that was passed this year. And it would allow Kansas businesses who are sued in these cases, if they can basically show using certain factors that these were really not exactly frivolous lawsuits, but somewhat abusive and how, kind of like a holdup or extortion to go after the plaintiffs and their lawyers to recover fees and possibly damages. I haven't seen this law used in practice yet, and it would be interesting to see if it does get used, but it was kind of an interesting development this year. And that law would actually go away if the DOJ does issue website accessibility regulations governing businesses. Moving down this slide, the next one, this is getting a lot of attention. California has a proposed bill that was proposed in June of this year, and it's referred to as AB 1757. That's the number of the bill in the state legislature. It would impose heightened standards on websites and mobile apps and require them to be accessible to persons with disabilities. It would make that standard I mentioned a few minutes ago, the industry standard, the Web Content Accessibility Guidelines 2.1 AA, the de facto standard for websites and mobile apps of any businesses that are open to the public. There'd be statutory penalties for noncompliance. It would expose business owners and web developers to potential liability. In August of this year, the bill's author requested that it be held in committee for further review, but we expect that it will be taken up and considered further and worked on further in 2024. And if this bill passes in California and imposes these standards on businesses for their websites, many expect, and Jason and I talked about a little bit about this, many expect there to be more litigation in California, saying that this law is being violated against various businesses if they don't comply. So we'll have to keep an eye on that and see what develops there. And then at the federal level, the US Congress, the last two Congresses, there was this Online Accessibility Act that was proposed but never got passed. That would have created a whole new title of the ADA, Title VI, that would specifically govern websites and mobile apps, and that would apply certain standards. But that has not gone anywhere. And then more recently, I think it was Senator Duckworth, who is herself disabled, has proposed the Websites and Software Applications Accessibility Act. I don't think we need to get into too much detail, however, because as I said, and maybe this is common with our US Congress, nothing seems to be moving forward with these proposed bills. And then at the bottom of the screen, outside the US, there are some laws, both in Ontario and in the European Union, which apply accessibility requirements to businesses' websites. So that's something if businesses are doing business outside the U.S., they certainly should be aware of those and make sure they're in compliance with
Chuck,
those.
how do you feel that? I mean, the most obvious law that definitely is going to take place, right, is the ADA Title II update, right? That will happen, I'm assuming, right? Because that's sort of like not up for debate. That's sort of just a timing thing, right? But
Well,
that's,
yes.
as you said, is primarily focused at organizations that get state and local funding, which would cover probably like state universities and other organizations. But how do you feel it would be used either by the plaintiff world or by the defense world in the more commercial space? You know, will it be used in sort of in support of plaintiffs, or to set a certain stat because it's got standards written in it? How do you feel that will actually affect the commercial world?
That's a good question, Jason. I think that would be used it would probably help the plaintiffs' lawyers. That 2022 guidance the DOJ issued and this notice of rulemaking, even though it only applies for now for Title II, both of those, if you look at those notices, and they're pretty extensive, they have a lot of language in them about basically reiterating and emphasizing that really websites should be accessible to disabled individuals. So I think there's a lot of kind of good statements in there and good content that the plaintiffs' lawyers can pick out and use and include in their complaints and lawsuits to further their cause of, you know, trying to get businesses to comply and arguing to the courts that businesses should be complying, and if they're not, they should be liable under the ADA and other state and local statutes. So I think it really probably benefits mostly the plaintiffs in this.
Would you see that plaintiffs would then maybe, I know there's a sort of a time window, right? The state and local organizations will get a couple of years, right? Mm-hmm. But as a present, state and local organizations aren't really being targeted by ADA lawsuits, and we can go into that, but they're not being targeted primarily. It's mostly commercial organizations, right? Commercial companies like online retail stores and stuff like that. Do you think that would change? Does that law open up an opportunity for, in 2 years' time, plaintiffs to then just target state and local organizations that haven't complied with the 2.1 AA?
Yeah, it's an interesting question. And I guess let me back up. Before I answer it, one thing I should say is that the August 2023 DOJ notice of rulemaking, it did talk about and recognize that it's virtually impossible for organizations to be 100% compliant with these web content accessibility guidelines. You know, websites are changing all the time. It's really hard to actually satisfy each and every single criteria or standard in those sets of guidelines. That I could see that maybe being used as a business to say, look, you know, you're being to a plaintiff. Typically in these complaints, we see them give 3 or 4 examples, the plaintiffs, of things on the website they couldn't access. You know, some of them could arguably be considered to be quite minimal, de minimis, we say in the law, nitpicky, maybe even. And, you know, is that really a crucial, essential thing you need on the website, or can't you get that some other way? So I could see a business maybe using that portion of the DOJ's publications or notices so far to defend themselves. But there's some interesting questions about the state and government entities, and there's certain laws that make them what's called sovereign. They give them sovereign immunity, or they cap the number of damages that can be obtained. We would have to see how that plays out, or maybe it's up to the DOJ itself or the Attorney General to enforce that. That raises a lot of questions. And of course, you know, these plaintiffs, if we're looking at it a little bit maybe cynically from the business's standpoint, the businesses would probably have deeper pockets than a lot of these state and local governments. So we might see the plaintiffs continue to focus on their attention and their claims and lawsuits on private businesses.
Great. Thanks, Chuck.
So, so just to talk a little bit about what we've seen in the courts. So as we said, because there's there hasn't been until recently any DOJ activity, the plaintiffs going to the courts have had to try to figure this out and sort through all this. At the U.S. Supreme Court level, I guess 2 things. There was a case that came out of California in the 9th Circuit Court of Appeals, which includes California. It was against Domino's Pizza, Robles versus Domino's Pizza. And it was an individual who said he tried to order online and then, you know, couldn't get his pizza from Domino's because the website wasn't accessible. Basically, that's a case in which the California and the Ninth Circuit Court of Appeals sort of set the standard to say that there has to be some nexus or connection between a website and a physical location. In that situation, a Domino's location or restaurant, for there to be a claim under the ADA in that circuit. That was, Domino's tried to take that up to the U.S. Supreme Court, and a lot of lawyers and others, businesses were hopeful that the Supreme Court would clarify and clean up the split among the courts about whether that connection between the website and the physical space is needed. But the Supreme Court declined taking that case, so it didn't provide any clarification there. But just a few days ago, there was a case, there's a woman, Deborah Laufer, who was in a wheelchair. She's handicapped. She lives in Florida. She was suing various hotels because their websites, she claimed, didn't have sufficient information on them about their accommodations and whether they offered accessible accommodations for disabled individuals. She was suing hotels all over the place, even if she had no intention of ever reserving a room there. And she was doing so on the basis that she was a so-called tester under the ADA, that she was just testing these websites for all disabled people. And she sued a hotel that fought her on this and said, you don't have standing, what's called standing. Under the law, you have to show some particularized harm or injury in order to have standing to assert a claim. And that case went up on appeal, and that did get to the Supreme Court, even though it was kind of odd. Ms. Laufer had dismissed the case before it got up to the Supreme Court, but the hotel company said, no, we need some ruling on this about whether this kind of tester really has standing under the ADA to bring a claim. Well, the court just a few days ago kind of left the law unsettled in that area as well. It said that the case was moot because it had been previously dismissed by the plaintiff. So there's still this question and split about whether testers have suffered a concrete injury or have standing to sue in federal court. So the law, we'll still see a lot of these lawsuits being brought, including by so-called testers, until that issue is resolved. In New York, I wanted to mention that we've continued to see in the cases in the federal district courts in New York, decisions saying that basically a website is a place of public accommodation. And that, as I said earlier, is probably why we're seeing so many lawsuits like this filed in New York. So, but there are, in contrast to that Laufer Supreme Court decision, we've seen some judges in New York becoming a little, I don't know, maybe frustrated or impatient with all these so-called serial plaintiffs. They keep seeing the same plaintiffs in these cases over and over and over. And there have been a few helpful decisions in New York, at least, although the Supreme Court decision may undermine this a little bit, holding the plaintiffs to a higher standard when it comes to standing, saying that you just can't make a general statement that you're harmed or, that you intend to go to this business. You have to really give some facts that actually show that you intended to use this business or you intend to return to the website. But, we'll have to see how that shakes out now. And then the other interesting case in New York this past year, Jason and I will talk about this a little bit later. While most of the settlements of these lawsuits are confidential, there have been some where the plaintiff and the business have decided to go to court and turn their settlement into what's called a consent decree. It's essentially a version of an order which the court then signs and really blesses. It turns it into an order that memorializes that the defendant business has agreed to settle. They've agreed to fix their website within a certain time period and so forth. Some think that will be a deterrent if other disabled individuals try that website later and have an issue and try to bring a claim. The business could say, well, look, we're already under a court order under this consent decree to fix our website, so your claim is moot and should be dismissed. There was a New York case this past year in which a court did actually point to a consent decree which had been entered before on a prior claim to bar and dismiss a subsequent claim. So that was an interesting development. It was a district court case in New York, and at the district court, those decisions aren't binding really on other courts, but they are persuasive. So anyway, that was kind of interesting. Well, again, we'll have to see what plays out from there. In California, as I mentioned earlier, that Domino's case at the federal court level in California established that in California, you need to show a nexus, a connection between a website and a physical space to have a claim, unlike in New York, as we talked about. And there have been a couple of decisions in this past year at the state court level as well in California requiring that nexus. So I think that's why we've actually been seeing the number of cases filed in California go down a little bit this year, whereas the ones in New York have increased. Because if it's just an e-commerce site that doesn't have a physical location like a store or a bank or anything, that's not enough in California under these decisions. And then Florida, as I mentioned, is kind of unsettled because that Winn-Dixie case kind of got undone on appeal, and there's no real governing decision at the moment in Florida about what you need to say or state to have a claim under the ADA. They were starting to see a trickle of other cases in other states. I'm in Pennsylvania, in the Western District of Pennsylvania, which is basically the Pittsburgh area. The courts have been similar to New York, actually, in saying that an e-commerce website is enough under the ADA. You can assert a claim. So there's been a number of cases being filed in the Western District of Pennsylvania. And we're starting to see, a few in Massachusetts, Minnesota, and some other states as well, kind of testing the waters. So, unless and until the DOJ and the courts, the Supreme Court or Congress, the DOJ, or all three really clarify the law and the standards in this area, we're going to continue to see a lot of litigation. And, the courts will have to figure out what to do case by case. You can move the slide, Bethany. So, Jason, I guess we're now going to, let me talk first about if you are sued in one of these cases, if you're a business or organization and you get one of these lawsuits, there are some possible defenses you can look at. Even though websites are online, you can still look at whether there's what we call personal jurisdiction over the defendant where the lawsuit was filed. And that requires the defendant business to have a certain number of minimum contacts with a particular state and jurisdiction in order to be required to defend a lawsuit there. And occasionally you'll get a case where the defendant really hasn't done business in a particular state. It maybe only had an isolated sale, if that. It doesn't have any employees, offices, doesn't do any advertising there. And then maybe you might have an argument to get out on lack of personal jurisdiction. We talked about lack of standing, and I put in parentheses here, credit unions. There were some helpful cases coming out, I think, of the Fourth Circuit Court of Appeals, where they looked at if the plaintiff sued a credit union, but the plaintiff wasn't even a member or eligible to be a member of that particular credit union, they couldn't really have standing because they couldn't even use that credit union. So that we saw some cases dismissed on that basis. Mootness means basically the defendant business has already provided the relief. They already have addressed the issue, or they are addressing it. We've seen a couple cases here and there dismissing cases on mootness, but it's usually the courts in most of the cases I've seen where that issue has been raised, they've denied the motion to dismiss and said, well, you may be fixing it, but this particular plaintiff who brought this lawsuit, he or she did have an issue and a problem, so they can proceed with the claim. We talked about the no nexus, that applies in certain jurisdictions. There's a cheaper way sometimes businesses go to try to address accessibility is with what's called widgets or overlays. It's kind of like a menu that gets laid over the website that somebody can click on instead of really recoding. Jason knows a lot more about this than I do. Recoding the website. Some will point to that and say, well, look, I put that on there and that's better than nothing. But we've actually seen plaintiffs' lawyers target businesses that use these because the National Federation of the Blind and a lot of the plaintiffs, the blind plaintiffs in this area, take the position that those so-called widgets don't really work. They actually make the accessibility situation worse if you're using a screen reader. We see a lot of these cases now being brought as class actions. I think cynically, maybe to try to get the amount of attorney's fees higher for settlements. Other than a couple where in Pittsburgh, where there's been an agreement by the defendant and plaintiff to certify a class of plaintiffs, really to help get closure and settle the whole thing. We haven't yet seen any classes get certified on a contested case where the defendant says that, class action, you have to show there's a lot of people that have the same issue, commonality among all those people. And there's a lot of reasons why I think a defendant business could fight whether a case could be a class action. A case like this, people use different screen readers, different operating systems, computers, it would be hard, I think, to show that they're all kind of in the same situation. And then there's certain state law claims, like in California, there's the Unruh Civil Rights Act, which has been used a lot by plaintiffs in this area. Essentially, a violation of the ADA can be a violation of that statute, but the plaintiff has to show that the discrimination was intentional. And that's a pretty hard thing to prove in a lot of cases. We can go to the next slide. So Jason, I guess now we can, with the time remaining we have, we can talk to the audience and the businesses and organizations that are on about what they can do to sort of help reduce the risk of getting these claims next year.
So I was going to say, Chuck, I mean, one of the, I can summarize basically based on what Chuck's also said, right? This is the way I look at it from a very practical point of view. If you get a lawsuit, most likely you're going to have to make a decision of, do you want to spend money on a lawyer to defend yourself, or do you want to settle? And Chuck will give you this. This is practical. Practical is that the first thing I would say is, if you get a lawsuit, you probably want to find someone who works in this space like Chuck, because as we said, most plaintiffs are a group of 10 or 12. They have a particular process in place. They are in the business of providing negotiating settlements, in terms of they will say, hey, if you want to settle and get rid of us, this is what it's going to cost. So, Chuck is going to be someone who knows what those numbers are, what that process is, how to potentially, quote unquote, present information that will help you negotiate that down. The reason I say that is,
I was going to also, Jason, I was going to add also, if you're writing up a settlement agreement and release, you wouldn't believe all the issues that pop up about the scope of releases, the language. So that's an important aspect a lawyer can help with as well.
Exactly. So unfortunately, if you get a lawsuit, most likely you're going to settle because you're not going to want to pay the fees to defend all the way to Supreme Court. You're going to want someone on your side in that negotiation that knows the other party and knows what they typically settle for. And you're going to want someone who writes a settlement agreement that's favorable to you, or as favorable as possible to you, based on their experience. So that's why I would say that you want to have someone like Chuck on your side. Even if you've got in-house counsel, this is a specialized area, and Chuck can save you a lot of time and money. So the key for me is, don't get sued. How can you avoid getting sued? Now, there is no blanket to avoid getting sued, but the good news is most of these lawsuits are brought by a group of plaintiff firms that follow a particular process to try to identify the types of companies and the types of issues. And I will tell you that these plaintiff firms do not spend a lot of time trying to find these issues, right? So that's good news, because actually, if you focus on what they focus on, you will most likely reduce the amount of risk that you end up in the top of the list of the sites that they're looking at this week, right? So essentially, that's why I talk about, making sure that, one, and this points to Chuck's point, right? What's your public facing content, right? Because that is the content that's most likely going to get sued, not your private behind username and password, but what's your public content? What's your public content? So like what is the most sort of used parts of your website and your apps, right? You could start with point number one. We have a free test on our website. Go to that website, test. You can test as many pages as you want. Test those pages. It will generate you a list, which looks very much like the list that gets put into lawsuits, because they're easy to find issues. But the good news is most of them are easy to fix. So take that list, send it to the people that you pay for your website, whether they're internal or external, and ask them to fix it. So essentially, when law firms are doing a quick scan and looking for the same types of issues, they don't find so many, right? I would encourage you to engage with a user tester who uses a screen reader, because that's what the majority of lawsuits are brought by. 99% of lawsuits are brought by someone who's blind, who uses a screen reader. So find a blind person, whether that's a employee, a relation of employee, customer, or go out to a firm that can provide you those user testers. and get comfortable with, does this user have a lot of problems on the site or not? If they have a lot of problems on the site, start working through making sure that they don't have problems on the site. If they don't have a lot of problems on the site and they're quite happy with the site, document that, because that could be useful later on for someone like Chuck, who might get a lawsuit from one user saying I can't do something, and you've got documentation. You say, well, we don't have a problem. So, we believe in telling our customers to make sure that whoever they're paying for their website, tell them now you need to know what's going on with regard to accessibility. They should feel responsible for making sure that your website is compliant with any laws that are out there. And you should make this as part of your contract. Like any new contract you write for any work that you do on your website or apps, make sure that you make the vendor responsible for accessibility. That does not remove your legal requirement, but it might help you cover some costs. I generally think that you should publish something about accessibility on your site. People call it accessibility statements. You should say it's important to you. It's an ongoing process. If you've got problems, contact me, contact us here. If you say contact us here, make sure whoever gets that information, whoever gets that communication knows how to answer those questions. Chuck, would you add anything else to those?
Let me just see. I think that you covered it quite well. I mean, there's also some practical things like to see if you have insurance for these kinds of claims, or you might want to get insurance. If you're a larger organization, you might want to lobby your representative in Congress and just say we need some action at the federal level to get some clarity here. But and then if you have forms on your website that maybe it's on your careers page or some kind of order form, I was actually expecting to see more claims kind of targeting those, but I haven't really seen that yet, but it could be an area where there is some exposure. So you want to make sure those forms themselves, that people have to fill out an online form, that can be done using a screen reader, that they are accessible as well. I think also if you, Jason's right. I mean, if you can get your third party, if you have a website developer, anybody providing content for your website, really try hard to negotiate in those agreements with those entities that they are responsible for making sure that content is accessible for people using screen readers and otherwise. And it'd be great if you get a provision that they would indemnify you if you do get a claim or a lawsuit. But you could go after them anyway if there's something in the contract where they've represented that the content will be accessible and it's not.
Great. We ran a little long, but we got some time for some questions.
In some of the cases that I've heard of, this is for Chuck, judges seem to be less strict when the respondent can show an ongoing effort prior to the plaintiff's issue to improve accessibility. Have you seen that too often be the case? So if they can document that they've worked on accessibility, or that they're working on accessibility, I guess.
Yeah, I generally agree. I mean, I think that if you show, even before you got sued, basically, you received the claim that you were taking steps to make your website accessible. And it's kind of a two-part thing, and I'm sure Jason will agree. It's not only making it accessible, like bringing it into compliance or substantial compliance with the standards we talked about, but also ongoing, continuing to monitor your website and make sure it stays in compliance. And I saw a case in New York where the defendant put in an affidavit from its either some kind of officer at the company saying we fixed it and we're committed to monitoring and making sure it stays in compliance. And the judge did look at that defendant a lot more favorably. So yes, I think that does help to document any efforts you're making. So in case you do get a claim, look, it may not totally win you the case if there is a claim and somebody had a problem accessing something, but I think it will help and show that you've done what you can and you're taking reasonable steps and so forth. So I think it would greatly help to do that.
So we had two people ask the same question here. It might be a question for both Chuck and Jason. Is there any certification that we can get for our website from a third-party organization like ISO or any organization that certifies that the website is ADA and accessibility compliant? And I assume the purpose of that would be to help defend against lawsuits, Chuck. So have you seen anything like that? And then Jason, do you have some perspective?
Yeah, I'll start, Jason. I think you may be more knowledgeable. I have not seen any kind of independent third party that does these certifications of websites. I have seen some accessibility consulting firms like, and I don't know if UsableNet does this, but I've seen there's a few out there that will give like kind of a little logo or stamp of approval that a business could put on its website to say that they have taken steps to make their website accessible. That's about all I've seen, though.
Yeah, from a UsableNet point of view, I mean, this is a component of how we need to support clients, right? So, you know, if a client comes to us that's had a lawsuit or someone who wants help with a lawsuit, right? We have resources in place to be able to review that lawsuit, check their website, see whether that lawsuit has validity. And then, you know, as part of our process, we're documenting everything that we do. We're documenting, for example, user testers from the disability community. We're building a body of work that we would use to help support a client push back on any claims. There is no such thing as the DOJ hasn't said, hey, these companies over here can generate you a certificate of conformance, right? And then that would be how you make sure that you stay in compliance. Interesting concept, right? You get a certificate of gas safety or whatever it is. Primarily, what you need to look for in a partner is a partner that is capable of and has the experience of supporting clients regardless of what happens. And if lawsuits happen, what is their process to support that client in the case of pushing back against those claims?
Yeah, websites are being added to and changed all the time. So I could see it being difficult for, the certification might be at that specific point in time that it's compliant, but then of course, how do you know that remains compliant? So that would be a little challenging, I would think.
With that, I'm going to go ahead and conclude today's webinar.